John, we've been doing this series on estate planning.
Yep.
And we thought we were going to do 3 episodes.
Right, because there's 3 parts to
But
the
here we are in
perfect
the
estate plan.
3rd episode, and we're not even halfway finished with this yet.
No, we're not.
So in the first 2 episodes, we talked about planning for incapacity.
That's right.
We talked about powers of attorney. We talked about the importance of those powers of attorney, the financial power of attorney, the medical power of attorney, so on and so forth, etc. We talked about long-term care option. I even challenged you a little bit on using Medicaid for long-term care.
That's right.
It was a good conversation.
Yeah, good times.
So if someone is just tuning in to this, I would encourage you to go back, listen to those first 2 episodes. It lays a lot of groundwork for the material that we're getting in today.
That's right. Yep. Yeah, you know, the last part of that, we were talking about the powers of attorney, and you know, when you're talking about the powers of attorney, you got the financial, the medical, the HIPAA release, and the last one is the directive to physicians or advanced directive, and of course that's you saying what you want at the very end of life, which is kind of a natural progression to the next part, which is the transition at death.
Yes, absolutely is. And so today, John, we're going to talk about handling transfers of your assets, the things you own, now that you've made it past the incapacity, which unfortunately means you're probably dead at this point.
That's right. You are.
So how do you handle passing these assets in a way that's efficient, in a way that doesn't cause chaos, and is generally thought out before you actually die?
That's right. So here's the kind of the main part of this, and this is a question that I get routinely, both from the living clients and the heirs of a deceased client, right? But here's the question: they'll ask, "Do we have to probate this will?"
Oh yeah, that's a huge fear that people have. Probate.
Do we have to probate this will? The interesting thing is that there's 2 ways to ask this question that mean they sound similar, but they're different, right? So there's one question, which is, do you have to probate a will in order for the will to be valid? Right? The answer to that question is yes in every single state of the United States. No will is valid until it has been admitted to a court, right? Everybody's heard like, well, you have to have witnesses, or you have to have a notary, or you know, they know that there's formalities, right? Well, it's the court after you die that ensures that those formalities were met, right? So just because you met all of the formalities doesn't make that a valid will. 2 things have to happen. You have to die, and the will has to be admitted to a judge has to look at that will and said, yes, this is a valid will. So the first question is, do you have to probate a will for the will to be valid? Yes. And there are time limits depending on your state. Texas, for example, you have 4 years following the date of death.
Oh, really? Now, that is something I didn't know. I didn't know there was a time limit on it.
Yeah. Arkansas, 5 years from the date of death. Other states vary.
Okay.
Right? So a similar question. Is there a necessity to probate this will?
Do you have to probate it?
Right. So those sound like they sound like the same question, right? Do I have to probate the will? But what we're asking is there a necessity to probate the will? And here's how I explain this in a presentation. I say, okay, so let's assume that I'm a hobo.
Okay.
Good old-fashioned hobo, right? Riding the rails.
That's your next career choice, I think.
Could be, right? I've got the clothes on my back. I've got my little stick with the hanky hanging off the end.
The picture-perfect hobo.
That's right. And in my hanky is a fried bologna sandwich. Now, we probably have some northerners that listen to the show and are not familiar with the fried bologna sandwich. I don't know. If you've
They may
never
not be familiar with bologna.
If you're not familiar with the fried bologna sandwich, you take a nice, good, thick piece of bologna.
Yes.
And you pan fry it. Now, the key here is you got to cut some slits.
Oh yeah, it'll
because otherwise
like
it'll
UFO.
bubble. It'll bubble up. That's right. So you cut some slits. You get a good, nice fry on that. Serve it on some white bread with some mayonnaise.
It's got to be white bread. It's got to be white bread.
It's got to be white bread with some mayonnaise. Now you can dress it up. I was at a fancy kind of one of these craft beer,
bougie
kind of places.
Place.
You know, and you could order you a $10 IPA And then they had the, kind of the bar menu, some fries and different things. And one of the items on there was a $15 fried bologna sandwich.
Yeah.
And now they had fancied it up. Instead of mayonnaise, it had garlic aioli.
Oh, for sure. Yes.
It came with a fried egg served on top. But I did order it, and it was quite delicious. It was, in fact, served on white bread, but nicely toasted Texas toast sort of thing.
I haven't let myself eat a fried bologna sandwich in so long. But I remember those. Now, when I was a kid, though, we didn't get the nice thick bologna.
No, you got some.
We got the stuff out of the package, right?
And you peel the little red.
Oh yeah, that's what we ate. But I've seen some of these Kraft fried bologna sandwiches, and they get the nice thick stuff that you buy in the deli, and it's thick cut. And it's
So anyway,
good.
Back to my story. So I'm a hobo. The only thing I really own is this fried bologna sandwich, right?
Yeah.
And I fall off the train. I get run over by the train, and I'm dead. Now I have a will, and my will says I leave everything to Devin. Now again, the will is not valid unless you take that will and hire you an attorney and file the will with the court, right? And if you don't do all of that, you will not inherit my estate because you're not a natural beneficiary of me, right? You're not my wife or my kids or anything. So if you want my fried bologna sandwich, you're going to have to go through that process. Well, in the county I live in, the filing fee at the courthouse alone, just the filing fee, is $427. That doesn't count the lawyer you had to pay to start this process because you can't do it yourself, by the way. I did not make this rule, but, like if you get arrested for doing whatever it is that you do, you have you get read the Miranda rights, you have the right to an attorney, but you can represent yourself in that criminal matter, right?
Sure.
You'll go to jail.
Yeah.
But you can do it, right? The old saying of the person that represents themselves has a fool for a client.
Yes, I've heard that.
Right. But in a probate case, you're not representing yourself, even if you're the heir. You're representing the estate. That's an entity.
Okay.
And if you walk into a courtroom and you're representing an entity, you have to have a law license, or it's the unauthorized practice of law.
Oh wow. Okay.
Right. So you cannot represent yourself. I didn't make that rule. It's not just to benefit the lawyers.
I bet some lawyers did though.
Probably. But in any case, so just the filing fee, right? $427. Would you pay $427 for my now probably several week old fried bologna sandwich?
Yeah.
And obviously the answer is no.
Not likely.
So in this particular case, there's no necessity to probate the will. Right. Well, let's add some stuff. Let's say that in addition to my fried bologna sandwich, I also had an IRA. But now I had named you as the beneficiary on the IRA. Well, when you name a beneficiary, that's what we call a non-probate transfer. It passes according to the contract. Right. And so that IRA's account agreement is going to say that if you have named a beneficiary and you're dead, then whatever's in that IRA goes to that named beneficiary, period. End of story. Whether you have a will or don't have a will is irrelevant. So again, I'm a hobo. I have a fried bologna sandwich and an IRA, but I've named you as the beneficiary on the IRA. So you get that automatically.
Yep.
Well, we're back to the question of, would you probate the will for the fried bologna sandwich? The answer is still no. So even though I have this IRA, there's still no necessity to probate the will. Trusts pass outside of probate. Beneficiaries pass outside of probate. Joint tenant with right of survivorship. So most of your joint accounts, those pass to the surviving joint owners outside of probate. Life insurance with named beneficiaries passes outside of probate. And so in many cases, it could be very simple to structure your estate so that everything passes automatically at death.
Right.
That's going to be a whole lot easier and a whole lot cheaper than going through that probate process.
Yeah.
Now, a couple of other things. Let's say that I owe people money when I die. So I'm a hobo. I got my fried bologna sandwich. I got my IRA that names you as the beneficiary. I also have a Discover card. And I've racked up a couple of grand of debt on my Discover card.
Okay.
And I've died, right? My creditors have a claim against my estate when I die. Okay? Right? Unsecured creditor, they have a claim against my estate. The word estate means what goes through probate. Right? So in, I think, most states, an asset that passes outside of the probate process, like the IRA in my scenario, right? That's not part of my estate. If it's not part of my estate, then it's not subject to a creditor of my estate.
Very good.
Right? So now, hey, if you were my heir, you'd probably be like, John always paid his debt, so I'm going to pay his Discover card off. And you would certainly be free to do that.
Mm-hmm.
You would have no legal obligation to do that. But for my Discover card, you might be willing to do that. Let's say that the reason I died was because I caused a car wreck.
Mm-hmm.
I was still driving late into my senior years, maybe probably shouldn't have been. I caused a car wreck. The risk of accident for a person who's 85 years old is statistically the same as a 16-year-old.
Yeah.
And I've had 16-year-olds.
Mm-hmm.
They are not good drivers.
No.
Now, are there good 85-year-old drivers? Yes.
Yeah.
Are there bad ones? Also, yes. Right? The difference between the 16-year-old and the 85-year-old is the 85-year-old dies in the wreck.
Yeah.
The 16-year-old's healthy enough to survive it. So I've caused this car wreck. I've injured somebody else. I've died in the car wreck. The lawsuit is a claim against my estate.
Yeah.
Right? Well, you might have been willing to pay off the Discover card, but you're probably not willing to pay off the hundreds of thousands of dollars in personal injury liability.
Right.
Right? But because I structured my estate as a non-probate transfer, all of that was exempt from my creditors.
Mm-hmm.
Right?
That makes sense.
So, and then let me add one other. We talked about this in the last episode when we were talking about the long-term care, and particularly on the Medicaid, right? And I think we even talked about that this kind of overriding rumor out there that if you go to the nursing home, they're going to take your house.
That's right.
Right? If I go to the nursing home, I've heard they're going to take the house. Again, they don't take houses. It's rent. Who does take the house is Medicaid.
Yep.
Not while you're alive, though. The Medicaid long-term care program is a loan from the government. It's not a gift from the government. And the way they collect on their loan is what's called the Medicaid Estate Recovery Program. MERP, MERP. But I don't know if you noticed, but there's the word again. Medicaid Estate Recovery Program.
Yeah.
They have a claim against your estate.
Yeah.
If the assets don't go through your estate, in many states, then they are free from the Medicaid claim. Now, I say in many states because some states have what they call expanded Medicaid estate recovery. And they say, even if the assets pass outside of probate, we can still get them. But many states do not have that definition, and they have the more traditional Medicaid estate recovery that only applies to probate assets. So I say all of that because why in the world would you structure your estate to go through probate?
Yeah.
It takes time. It costs money.
Yep.
And it subjects your assets to creditors before your beneficiaries.
Yeah.
That's almost a no-brainer.
Right. I mean, right off, it seems like that you should try to structure everything to stay outside of probate.
Yeah. So that would be my general philosophy is keep, so, our big parts of a good estate plan, right? Part one, have a plan for incapacity. Part two, have a plan for non-probate transfers at death. Now, a couple of things to keep in mind in all of this. So one, again, a good way of doing it is using trust. I'm a big fan of using trust for as opposed to wills to plan your estate. But a lot of people do have wills. Even if you're planning to pass all of your assets outside of the estate, right? But again, I'm a hobo, right? The only thing I have is the IRA. I've got you listed as a beneficiary. That's going to pass outside of probate. So the natural follow-up question to that would be, well, do I even need a will? Probably not. I mean, if I die and I leave all you get is the IRA and it names you as the beneficiary, well, then I didn't need a will.
Mm-hmm.
So my grandfather died years ago. I had done his estate, and at his death, everything passed to my dad and my aunt automatically, nice and simple, easy breezy, right? Non-probate transfer. So about 2 years later, I'm sitting in my office and I get a call from a landman. And, you know, I would probably have to explain what a landman is, except now there's a TV show called Landman.
I've seen that. Yeah. No, I haven't watched it, but I've just seen it pop up there.
So, but anyway, so I get a call from a landman who is researching mineral rights in Conway, Arkansas. Now, understand my grandfather died in Granbury, Texas, which is on the other side of Dallas and Fort Worth area. And so anyway, this landman calls and he says, "Hey, are you John Ross?" And I say, "Yeah, I'm John Ross." And he says, "Are you John Kelsey Ross? Middle name Kelzy." And I said, "Yep, you got him." He said, "You ever live in Conway, Arkansas?" And I said, "Nope, I've never lived in Conway, Arkansas." I said, "But I tell you one thing. My full name is John Kelsey Ross IV. And there have been 3 other John Kelsey Rosses in the United States since the beginning of the country. And I know who the other 3 are." My great-grandfather lived in Conway, Arkansas. And he said, "Well, that's what I needed to know because I'm researching deed records. And I've found where a John Kelsey Ross, back in the 40s or 30s or something like that, sold a piece of property and kept the mineral rights. Well, those mineral rights have never produced. They've never done anything. That deed has just sat there in the court records or in the deed records all this time. But now I represent this oil and gas company who's looking to drill on this particular piece of land, and we need to know who to pay." Well, of course, those were my great-grandfather's mineral rights, which means when they died, they passed to my great-grandfather. Except since they had never produced anything, my grandfather never knew he owned them.
Wow.
Right? Nothing had ever happened. So when I did my grandfather's planning, we did not do anything to transfer minerals in Conway, Arkansas. We could have. We could have done a transfer on death deed or a beneficiary deed, or I could have put those minerals in his revocable trust. We didn't do any of that, though, because we didn't even know they existed. So on the possibility that there was something that did not have a non-probate transfer affixed to it already, we did a will as a backup. Now, it didn't have to be a fancy will, you know, leave everything to my kids in equal shares. Did we have to file the will in Conway, Arkansas? Yes. Did we have to go through the process up there? Yes. Was it a simplified process because the value of the estate was so small? Also, yes. So was it cheaper? Yes. Was it easier? Yes. So even though we did have to probate that will, it was still a smaller probate, an easier probate.
Mm-hmm.
And it was a good idea that he had a will as a backup.
Right.
So the question of, well, if I've got everything set up for a non-probate transfer, well, then clearly I don't need a will. Well, no, not clearly.
Right.
You probably don't need a will. But stuff happens, you know. I had, a while back, we had done a revocable trust for this married couple, husband and wife, plenty of money, right? Plenty of money. And the husband, he liked to put a little money on the football teams on Sunday. You know, $50, see if the Cowboys win, you know, something like that, right? He did not have a gambling problem. He was not betting large amounts, but he liked to make Sunday a little more interesting with a few bucks on the game, right? This drove his wife batty. She absolutely could not stand the fact that he would waste $50 on a Sunday for nothing. And so one Sunday, they get into a big old fight about this. And he says, fine. So he goes over Monday morning and he pulls $50,000 out of their bank account. Now, their bank account was in the name of their revocable trust. But so that his wife would not have any access to this stupid thing, he took those $50,000, he went and opened up him a brand new bank account just in his name, nobody else listed on it, and that's going to be his gambling account. And he put $50,000 in there. And again, this was a tiny percentage of their overall estate. And he had a heart attack 2 days later and died.
Oh, man.
Well, of course, the wife immediately went over to that other bank account and said, I want the money out of there. And they wouldn't give it to her. They said, we need letters testamentary. Well, what letters testamentary are is when you probate a will and you're appointed as an executor, the court issues an official document saying that you're the executor. That's called letters testamentary. And so they were telling her, you need to go probate a will.
Yeah.
And then she storms into my office, mad as a hornet. Now, as we like to say in the office, sometimes people, you got to give them a little grace.
Yeah.
She's just lost her husband. She's upset. She's upset that she's lost her husband. She's now frustrated, and she needs to take it out on somebody. That somebody was us.
Yeah.
And she is mad as a hornet because we told her she wouldn't have to go through probate. Well, she wouldn't have.
Yeah.
But luckily, we had a will as a backup. We were able to probate the will. She did understand, and she understands that her husband is the one that created this problem, and it's not our fault, and it wasn't her fault, other than maybe her nagging that led it to all of this.
Yeah.
You know, the $50 that he was gambling was certainly cheaper than the probate process.
Yes, I would think so.
You know, but she also had no other way of getting to the $50,000 in the bank.
Right.
So it's a good idea to have the will as a backup.
Yeah.
The last thing I'll probably mention on this is the importance of understanding the difference between the probate transfer and the non-probate transfer, because you mentioned earlier that was 37% of people have a will in place.
Yeah. Yeah. It was somewhere around that 34%, I think.
So about a third.
Really small.
Yeah, I've always heard that a third of people.
Yeah.
But what I don't know, but what I suspect is that of that third, the majority of them are will-based planning. You know, I've already today I've had somebody come to my office and they wanted to get a will. You know, we ended up going a different direction, but they came in wanting to get a will. If they had gone to, you know, Schmitty, their divorce lawyer from 1975, and said, I want to get a will, he'd have probably done a will for them.
Oh, he certainly would have.
Without giving them any advice or talking about probate transfers versus non-probate transfers. Yeah. He'd have just done them a will, right? And so I have had lots of people come in and they have wills in place. And then there's unique planning in those wills. So, for example, the will say maybe it created a trust for the surviving spouse, or maybe it had a disproportionate distribution at death. Like, you know, we loaned Billy $20,000 and he never paid it back. So in the will it says take $20,000 off of Billy's share and and then split everything 3 ways.
Yeah.
Right? And then I'm looking at the will and I say, okay, well, I see what you've written here in the will. You want to take $20,000 off the top of Billy's. Well, let's talk about your estate. Well, you got an IRA? Yeah. Who do you have named as beneficiary? All 3 kids.
Yep.
Who's on the life insurance? All 3 kids. You got payable on death on your bank account? Yep. Who? All 3 kids. So everything they have is going to pass outside of probate.
So Billy was about to get a free loan.
So Billy was about to get a free loan, right? So you've got to understand that if you have planning in your will, if you want will-based planning, that will only controls what goes through the estate.
Absolutely.
And so if you've got, you know, where I've seen somebody with a special needs child,
yep,
and they have a will that creates a special needs trust for their special needs child, but then they've got that special needs child named as the beneficiary on their IRA, not the will.
Yeah.
Right? And so if you're going to build in planning to your will that is only controlled by the assets that are in your estate, then you need to make sure all your assets go through your estate.
Mm-hmm.
The problem is that this is where a lot of times there's miscommunication with the financial advisors, right? Because the person goes to the lawyer and they they talk to the lawyer about wanting to get a will and all the things they want in the will. And the lawyer does all of that. Probably still doesn't explain non-probate versus probate transfers. Then that same person is talking to their financial advisor. And they're saying, well, what do we do with this account when we die? And the financial advisor says, oh, we need to name the beneficiaries on this account. Otherwise, it's going to have to go through probate.
Mm-hmm. And
if it's an IRA and it goes to your estate, that's a 5-year tax payout.
Yeah.
So you don't want that at all. So we're going to need to name beneficiaries. But the financial advisor never said, well, wait a second, is there anything in your will that conflicts with this?
Mm-hmm. Right.
The lawyer never asked, is there anything about your financial stuff that will override what's in the will? And the financial advisor never figured out if there was anything that they were overriding by doing the beneficiaries. So those were never talking.
Mm-hmm.
So in large part, because of that, it is somewhat up to the consumer. You out there listening to the show, you have to know the difference between a probate transfer and a non-probate transfer, what they do, what they don't do, the pros and cons. And then don't walk into that lawyer and say, I need a will. Walk into that lawyer and say, I need advice on how to transition my estate at death. And I've heard from these two brilliant podcasters that I should probably structure it as a non-probate transfer.
And John, that's exactly what they would say.
I would hope that's what they would say.
There's no question that our listeners would say that. I've read our reviews.
That's right.
The ones who praise us especially. I have read those. So there's a lot to cover in the non-probate transfers and tax considerations. And man, after that, we still have to talk about some of the other beneficiary issues, right?
Right, because along with the transfer at death is the tax issues associated with the transfer at death, both to the estate itself and to the beneficiaries.
Yeah. Well, I don't know of anywhere else there is such a primer on estate planning as what we're offering here. This is going to be fantastic as a resource to go back and listen to over and over again. For our
people pay good money for this.
They do. Real good money.
Yeah.
Like lawyer fees.
Like lawyer fees. That's right. And you're getting it for free right here.
No question. Can we wrap it up right here?
I think we should. Because, once we get into the tax stuff.
Yep. Then it's hard to stop.
That's going to be a whole nother thing.
Absolutely.
And so, here I am beginning to think that our 3-part episode is going to end up as
6.
I think it's going to be 6-part episode. We might, I tell you though, we might be able to squeeze the last one into a single. Okay. So it may be a 5-part, 3-part episode.
Okay.
But it may be a 6-part, 3-part episode.
If we get to running our mouth.
It's definitely more than 3 at this point though.
Oh, at this point, we're halfway. We're 3 into this, and
and we're not.
I don't know that we haven't hit the halfway done.
Yeah, of the 3, we're 1.5 right now. Yeah, so
we're getting close.
All right,
very good. Well, let's wind it up there. And John, reviews are still coming in. Fantastic reviews. Our listeners are excellent, leaving us those reviews. And some people say that it doesn't matter if you get reviews or not with how Apple Podcast will share your podcast. But I'll tell you this. What do you look at when you are shopping on Amazon?
Reviews. Yeah.
And there's something about the number of reviews that matters.
Right.
Well, if somebody has 5 or 6 reviews, you just automatically assume that was family.
Right. Yeah. I mean, if I listen to a lot of audiobooks, right? Mm-hmm. And so when I'm searching for a new audiobook and I see something that is a 5-star audiobook, it catches my attention.
Yeah.
When I see that it has 2 reviews that are 5-star, I figure that's his mom and his grandma.
Yeah. He couldn't even get his writer to leave a review.
Right.
And they always do that.
Right. The publishing company didn't even give him the 5 stars, right? Yeah. So yeah, but if I see 4.9 and there's 7,000 reviews, I'm impressed.
Yeah.
I figured that must be pretty dang good.
Yeah, I would say so. Well, let's wrap it up here, and we'll come back next time and start talking about tax considerations.
Sounds good.